Thank you. We are live. Okay, David, can you walk us briefly through what the houses did on the eviction section? I think you may have already, but let's do it one more time. And then we'll have the advocates talk about it.
David, you're muted.
I'm happy to do that. My impeccable timing, I understand. My Microsoft Word is not working, and that makes it quite hard for me to be able to do that for you. And I have no idea why. It's really frustrating.
Either maybe Peggy can pull it up, or if you can email it to the section to all of us, we can print it out, and it's not that long.
Yeah. That's the problem. I can't email it because I can't open it in Word. I can pull it up on the screen from your web page.
Okay.
And we can quite honestly, we can look at it on our web page. And it's up. It's remind us which day it might.
Well, you can just go directly by bill. If you go to your web page and then search by bill and go to S79. You'll see House General Draft 3.1 dated 5/6/21 under my name.
Right.
So that works. Got it.
And then as I recall, the 2.1 had the differences between
That's right.
The Senate in yellow.
That's correct. But bear in mind that this is brand new, so it would all be yellow anyway. I'm gonna. There we go. So you should be seeing eviction moratorium on your screen.
Got it.
Great. So in a nutshell, and I know you're pressed for time, I'll be quick. Remember you passed the Act 101, created an eviction and foreclosure moratorium, the duration of which is the governor's declared state of emergency plus 30 days after that. And during that period, eviction actions, foreclosure actions are basically frozen in time. You can initiate them, but you don't go any further. Everything is just frozen in the ether. And again, that holds true for the emergency period plus 30 days. However, the court has been operating under AO 49 this whole time. It's been amended bunches and bunches of times. And that always contemplated that a court could act in emergency circumstances if necessary. However, what constitutes emergency circumstances was always supposed to be up to the courts to decide as a matter of fact and law. This is emergency. This is what we should do. You'll see on the screen, you had said specifically in that act that it was not your intent to limit a court's ability to act in an emergency pursuant to AO 49. And you specifically added language that said that could include an action that involves criminal activity, illegal drug activity, acts of violence, or other circumstances that seriously threaten health or safety of other residents. Other things have come up over time, and courts have been very narrow in their reading of what may constitute an emergency.
David, could you go back? I'm confused.
Yep.
What this first section means, because there's no lead into it, so it's limited. Right. So what is this, an exemption? Nothing shall limit? Is that what it means?
So this is from the underlying act, and this is found towards the beginning of the act where it says basically what the duties are. You still have to pay rent. This is not intended for limit a court's ability to act in an emergency. That type of stuff, that kind of intro language in the act.
And the House took out this language, which I see stricken here.
So what we're doing here is creating a new subsection I that will specifically address actions for ejectment based on emergency.
Right.
Okay. Got it.
So
Okay.
we don't want to affect the court's ability to act under AO 49. We're not changing that. We're just cutting this and pasting it into a new subsection below. So that new section, that new subsection I, action for ejectment on an emergency basis, it spells out and provides more sort of a broader range of examples that the legislature would consider to be potential emergency circumstances in which the court could act in an eviction proceeding. So under 1, notwithstanding anything else in the moratorium, a court may allow an ejectment action to proceed on an emergency basis pursuant to VRCP 65, which may include an action that involves the following circumstances. So these are the things that could include, again, criminal activity, legal activity, acts of violence, other circumstances that threaten health or safety, including tenant tampering with, disabling, or removing smoke or carbon monoxide detectors. B, the landlord needs to occupy the rental premises. C, the tenant is not participating or does not qualify for the Vermont Emergency Rental Assistance Program. Or D, continuation of the tenancy would cause other immediate or irreparable injury, loss, or damage to the property, the landlord, or other residents.
So these 4 things, if you don't meet one of these 4 things, we're saying that the court, even if they thinks there's an emergency, can't deal with the problem?
No, to the contrary. The court has the ability to act in emergency circumstances. That's what the thing says above.
Right.
And then this says action to proceed on an emergency basis may include the following.
Yeah.
So we're not limiting the court's ability to assess and address what it considers to be emergency circumstances. But again, because the court has taken a pretty narrow reading of what that means, and they mostly have limited it to what you had in the statute, you're adding some more pieces to the statute for basically for guidance.
May I ask a question?
Please.
Yes.
Subparagraph C, not participating in or doesn't qualify for the emergency rental assistance program. How would the landlord know that? Do you know?
I think it manifests in lots of ways. I would defer to Angela for real world examples, but it depends on which program you're trying to go through. I mean, that's specific VRAP, but there are other funding streams. And in some cases, I think at first the landlord had to have the tenant sign on. Other cases, the landlord could do it on behalf of the tenant. So I think
that's again, one of the problems that I'm hearing about the most is the landlord says that the tenant is working, hadn't suffered any loss, refuses to sign any papers necessary for the landlord to get paid, and the landlord as a result is not getting paid. And so that's why, just the reason for my question of how did the tenant know this person isn't participating as opposed to isn't cooperating?
Sure. I just would venture the guess that if they're not participating, you're not getting paid, right? If you're the landlord.
Well, yeah, but they may be participating and you're still not, and the tenant is not cooperating. So and maybe Angela will be able, but somebody ought to be able to answer. How does someone implement this? Is the information that they're not participating or doesn't qualify? Is that information that is in effect semi-public that the landlord can find out?
All right, I think we'll let Angela answer that question. But let's go back to Angela after we finish with David.
All right.
Can I ask a question?
Yes.
I just didn't see, David. I was Googling like the difference between an eviction and an ejection. Do we maintain a legal distinction in our statutes between an eviction and an ejection? Is an ejection faster? It seems to have a lot of different definitions.
There's no difference for purposes of our law. It's just that I think eviction is sort of the generic term that everybody's kind of familiar with. But in our statutes, it's actually called an ejectment action. And that's not limited to necessarily residential tenants, but ejectment is where you literally try to get somebody off of property when they're unlawfully occupying it. But for purposes of our statutes, we start in 9 VSA 137. We have some basis for terminating a tenancy. And then if a tenant doesn't vacate the premises within a certain amount of allowed time, the landlord would initiate what we call an ejectment action. And that's a court procedure in Title 12 that has various steps for removing somebody from the property, which culminates in the issuance of a writ of possession, and then that is executed by a sheriff if necessary to physically remove a person, but that's ejectment.
Okay.
All right, so the subdivision 2 here, so upon a plaintiff's motion to proceed under this subsection, you have to be supported by an affidavit. The court shall determine whether the plaintiff has alleged sufficient facts to warrant a hearing concerning emergency circumstances as provided, and if so, the court shall issue any necessary preliminary orders, schedule a hearing, allow the plaintiff to serve the defendant with a motion, affidavit, complaint, preliminary orders, and the notice, and after hearing, issue any necessary orders, which may include issuance of a writ of possession. So the first part, I1 sort of goes to what are we talking about when we say emergency circumstances, and then 2 says, all right, if we have emergency circumstances, court, you may proceed notwithstanding the moratorium and follow the normal steps for resolving this dispute.
Okay. And this, the effective date, this section continues to terminate 30 days after after the lifting of the executive order.
Right. I mean, this subsection I would take effect on passage of S79, but Act 101, the Eviction Act, the Moratorium Act would stay in effect for 30 days after the governor officially declares the end of the state of emergency.
Well, we're making changes to 101, right?
Right, but it has its own effective period, and we're just amending within that.
So if we amend a previous law, it has its own effective date, then, or sunset date, that still controls the changes as well as the original bill?
Yes.
Okay. So what are we accomplishing in like 2 sentences? What are we accomplishing here?
I think you're expanding the universe of guidance for what the legislature considers to be emergency circumstances that would permit an emergency action in the courts.
We're enabling more reasons to evict a tenant,
Yes,
right? I mean, isn't that what we're doing?
I'm sorry, I was on mute. Yes, I think that's what we're doing. And I can see the enumerated reasons here. How do they differ from what's in 101?
101 is basically
Is that the language?
specifies these circumstances, right? I mean, 101 is a matter of law, is not limited to these 3 or 4 things you see highlighted, because it was never the intent, nor does the language limit the court's ability to act in emergency circumstances. But again, my understanding from the testimony and from the constituent communications that have been shared is that the courts are taking a very narrow view of what constitutes an emergency, and the intent of this section is to put more shape on what should be considered an emergency or potentially an emergency.
So, okay, that's clear. So I'm getting back to Senator Brock's question. We'll have Angela on next, but in subsection C, the tenant is not participating. Is this the law from the Consolidated Appropriations Act, or is this meant to include the ARPA funding for rents as well?
I don't know if the ARPA funds will be put into VRAP. I'm not sure how that money flows.
Well, that's a huge pot of money that's going to start flowing soon. That should be in here as well, I would think. But the language is a little interesting in the sense that if a tenant is over income for this program, does not qualify for the program, then by definition, you subject that person to eviction because he's not low income.
Yeah, that's an interesting construct. What was the objective there? Because
I mean, I can see, it's saying not participating if you're otherwise eligible, because there's money out there that can help everybody. And, and if a person wants to, for whatever reason, not take advantage of it, that hurts the landlord as well as the tenant. But if a person
Well,
has,
I think what they may be getting at is in the case of a tenant who is not paying rent,
Right.
and those funds are available in these programs, that is, I think, the intent of this, but it doesn't say that action will definitely force it. The fact that these conditions will necessarily allow an eviction, it just says may include an action that involves.
right, but that's true, Senator Brock, for every one of these things.
Yeah, exactly.
Yeah. So as David said, it's broadening the reasons out there that the court could look at. They seem to be deferring to the legislature as to what reasons they would have an emergency hearing, and now we're broadening that. But Angela, can you talk about this section and in general, introduce yourself?
Sure.
But
Absolutely.
But especially that last section, it does seem kind of bizarre to say someone over income for the program can be evicted just because they're over income for the program.
Right. So thank you, Senator Sorokin. My name's Angela Zakowski. I am the director of the Vermont Landlords Association. And to, I guess, jump right into specifically to that particular section, we've been receiving reports. I know legislators have been hearing reports. We have sort of two issues, and I'm going to focus right on this new rental assistance program, because that's sort of what's driving this section. This new rental assistance program, the Vermont Emergency Rental Assistance Program, which we've all been referring to as VRAP, requires tenant participation. It requires the tenant to put in an application, and it requires the tenant to produce income information to get approved for the program. And so there is no funding mechanism in this program for landlords to receive rental assistance without a tenant participating. So in our prior program in 2020, if a tenant was refusing to participate, there was an avenue for landlords to access some funding. They didn't get full funding, but they were able to receive some funding. With this new program, there is no funding available for a landlord to get by themselves without a tenant. So that's the reason why the first part says tenants refusing to participate, because the landlord has no other recourse if a tenant is not paying the rent. And because we don't know how long the state of emergency is going to be in place, I mean, we already have landlords who have not received rent now for 5 months because the prior program expired
in December.
Tenants have continued to not pay rent. And if they're now not participating, they're starting to hurt. There's no other, they don't get to apply for PPP. They couldn't apply for economic assistance grants. There is no other funding stream for them to help offset their own expenses on these buildings. So we were left with a situation where either there's an exemption to the moratorium for a landlord in that situation, or there was going to need to be some other funding stream created. And this is the way the House decided to go, is to include this in with the moratorium. Now, could a landlord start an eviction under this clause for non-payment of rent, and then the tenant gets involved and gets their application into the process? Yes, that could still happen. And I think the hope is that's what will happen in these situations. But the landlord needs some tool to be able to push the tenant to get there, because in many times that's not happening. The second clause to that does not qualify to participate. So the new VRAP program has income eligibility guidelines. If your income is above 80% of AMI, you cannot get assistance through this program, which means you're generating income that, I mean, I'm happy to provide the committee with the AMI chart. The amount of money that someone would have to make to be above 80% AMI is relatively significant and means that they should be paying their rent. But we are hearing stories of tenants saying, I'm not paying the rent because you can't evict me and there's nothing you can do about it. And that's the situation that this was trying to fix or solve. And again, it's if the tenant does qualify and they just haven't applied, there's a way to fix that. You know, maybe the tenant just is saying that and they really can't afford to pay, but the landlord doesn't know. All they know is they're not receiving rent, and there is no way for them to access funding to help them stabilize their building from a financial standpoint.
So just clarify for me one thing. There was a pot of money, I think it went through the Joint Fiscal Committee of $110 million in rental assistance coming from the Consolidated Assistance Act from December 27th.
December. That was December's program.
December's program. That is now up and running at VSHA, right?
That's the VRAP program. Yes.
Is that the one that's referred to in this bill?
Yes.
Okay. There's another pot of money coming through ARPA, isn't there?
Correct. And I don't believe that the state, I mean, I think the state has applied for those funds, but they have not been received yet. I will say from the rental assistance piece, ARPA looks very similar to VRAP.
Right.
Oh, does it? Mm-hmm. So it's all based on income eligibility?
And tenant participation. Yep.
Which is a challenge, really a challenge for landlords. What we did with the CARES Act money was much more landlord friendly, in that it went directly to the landlord to pay the rent.
Well, and it allowed the landlord to apply in if the tenant wasn't participating.
Yeah, that's right.
And these two, the VRAP and then ARPA when it comes, does not have that mechanism.
Right. And ARPA hasn't come yet. We have not appropriated that yet. No, we still have this vast amount of money that we got in December that we're still working through. And we have, I don't know, it would be great to obviously get an update at some point from Richard about how that's.
I think it is going well. From what I've heard, I don't want to put words in his mouth or in his program, but they have the last numbers I saw, which were last week, were somewhere in the neighborhood of 1,600 tenant households, and the money part I don't remember. I know they had processed about 1,600 tenant applications. So people are finding the program, they are applying, they are getting approved. But we have this subset, and we know that from the 2020 program, that there's just a group for whatever reason don't want to sign the paperwork, don't want to participate. And the substantial majority of landlords applying for the 50% rent, so the reduced rent under the 2020 program, indicated it was because the tenant wouldn't return their calls, wouldn't sign the papers, wouldn't do what they needed to do so everybody could get full money.
So Angela, so your counterpart on these hearings is usually Wendy Morgan, correct?
Correct.
And I don't see her here. Is she with us?
No, she's not here.
Okay. I thought we reached out to her, but maybe not.
You want me to,
You try and reach her if we can, yeah.
I will.
I did send her the Zoom information.
Yeah, it's interesting. Okay,
Who's I
so
think
here's my dilemma, Angela, on the second clause. I understand that in many cases, this may be a substitute for people unwilling to pay the rent. But in certain cases, they may be unable, for whatever reason, to pay the rent. And just because their income over whatever period, and we don't necessarily know all the details of how you qualify for the new rental assistance program, we're making this blanket statement that you're subject to eviction. And it seems like we need to be a little bit more refined in that. Otherwise, we're, taking cases of non-payment, which is the traditional eviction cause, and saying, even though we have a moratorium on it, we're saying for people who can access substitute funds, yes, they can proceed with evictions, but for people who can't, and we don't know for sure what the reason why they can't, we're in a blanket statement saying they're subject to eviction.
May I just interrupt Michael for a sec? Peggy, could you send Wendy the Zoom link? She didn't get it. And she's ready to join us.
Will do.
Thank you.
Senator Strachan, maybe to alleviate some of your fears, there's actually two ways a tenant can qualify for VRAP. So they can qualify by supplying their 2020 tax return. So if they were under hard economic times last year and would qualify based on their 2020 income, that's what they can provide to the program and get qualified. If they've had a more recent change in income or a more recent situation where maybe their hours were cut or they lost a job or had some other sort of issue, they can provide their prior month's pay stubs and get qualified in that fashion. So it seems to cover both of what you're concerned about, which is if somebody is facing sort of a short-term hardship that's more recent, they should still be able to qualify. If they're above that 80% AMI threshold, then no matter what else is going on, they aren't going to qualify for the program. And I think, the balance is then you're telling landlords, we're not going to help you. You haven't received rent. Sorry, there's nothing here for you. So the ask from the landlords is, please help us. We're here. We've been trying to participate. We've been trying to do the right thing, and we're getting stuck. And we're having our own economic crises because we can't pay our bills.
Yeah.
Okay. I think Senator Brock has left us. We'll go on for a little bit more. I hear you. That alleviates the fact that there could be a floating income period. Will alleviate probably 90% of my concerns in this group. But you could have somebody with income steady just above the threshold, and the fact that they have that income doesn't mean in their particular circumstances they're not facing other hardships like childcare or health conditions or other things like that make it difficult for them to pay their rent, but you continue as a blanket statement here, say those people are subject to eviction. Is there anything in this law or this provision here that you think would play out in those oddball situations that a person could make that case to block the eviction?
I think a tenant could absolutely come in and make that case, right? Remember, so there's a couple of hurdles the landlord has to go through. First, they have to provide a motion and an affidavit to the court saying, here's the evidence supporting us fitting under this moratorium exemption. So that's hurdle number one. And if the court says, yes, you have met the conditions and it appears you qualify under this moratorium, we're going to schedule it for a hearing and we're going to hear from everybody. And only after that hearing would the court then make a decision, yes, landlord, you have sufficiently proved emergency and compliance with the statute or compliance with these requirements. A tenant in that situation could certainly come in and say, here's my situation.
Right, and I hear you, and I'm sure most judges would listen to that evidence, but the way the statute is written, I could see a creative landlord saying, oh, the legislature said if someone's above the income threshold for these things, we have good cause to be here on a non-payment of rent case to evict the person. I don't disagree that it probably would be a rarity, but the way I read the law, and I don't know if you read it otherwise, that is a possibility.
Things are always a possibility once they hit the court.
Okay.
Right.
Let's, is Wendy with us now?
Yep, Wendy's with us.
Okay, Wendy, we want to talk about this one section you may have picked up on. I don't see her yet. Let me see.
Yep, she's right there on our screen. And when in the evictions expansion,
Section 16 is
Yeah.
on page 34. Yep.
page
Okay.
35, yeah, 34, 35. Yeah.
So, sorry you missed our first part of this meeting, but if you can just give us sort of your overall view of what this amendment does and whether it's good in your opinion, and then we seem to focus a little bit on this section that says a new reason for evicting people that the court can look at, and they've been given deference to the reasons that the legislature has put forward, is that you're not qualified for a federal assistance program. And what Angela has been saying, very articulately, that, that's sort of a substitute, that these people have enough money to pay their rent and they're still not paying. So if you can comment on those, that would be great. Well, and we're only going to go to 9:45, so you have about 10 minutes.
I don't think I could talk for 10 minutes on this topic unless you ask me questions. But let me just say, I think this section is a balance between the needs and rights of tenants and of landlords. And that's what the House was trying to do, given the testimony that it heard with regards to the eviction moratorium. And I just caught the end of what Angela said, and I completely agree that there are many stages to this. The person has to first submit a complaint, and then a motion for an emergency hearing, the court with an affidavit, which has requirements on it with regarding being able to assert to the truthfulness of the facts that are presented. And then the court has to decide that what was asserted is sufficient to overcome the emergency situation. And then there would be a hearing. The only thing I would add to after which the court could issue an order, and the only thing that I would want to point out that Angela did not specifically state, is that the court can issue any sort of order. It doesn't have to issue an eviction order. So it could order the person to pay rent or pay rent into court. after it hears the evidence. And only after that order is not complied with and the person is brought back into court would you have an eviction order. At least there's the potential for that. Or there could be multiple orders before there's finally an eviction order. So I don't want us to assume that every single case that's brought in under this provision would end up with an eviction order immediately. With regards to not participating in the large C that you were talking about, does not participate or does not qualify for Vrap, I think that is basically trying to indicate that the person could pay rent and isn't paying rent. And I think that the court would get to that question in a hearing. One of our concerns about this provision is that in fact, Vrap is not working that well yet. So tenants and landlords are not getting payments. By and large, they're not getting payments yet. They're just sort of beginning to start making payments. So, but I frankly think that by the time this becomes law, I certainly hope that the vast majority of those situations will have been cleared up and people who are eligible for Vrap will have gotten it and the landlord will have been paid. So if your concern is about that C language, it's not of concern to us.
Great. Well, that's helpful.
My concern is not with the first part of C, but the second part. I think that people should be required to seek this fund to help themselves and their landlords out. But when they're not eligible for the program because they're over income by $1 or something like that and have other reasons as to why they're having difficulty in meeting their rents, do you not have any concerns that those people can unintentionally get swept in?
I think the courts will listen to what their situation is and either agree that they're sort of actively not paying rent when they could, and will order them to, or will make another appropriate order given the facts before the court.
Okay. Okay. Anything else either of you would like to add while we're still on? We have 5 minutes on S79, other parts of the bill.
I just would like to echo what Wendy said, which is this has been a balance. And the provisions in there sort of took from both proposals made by my organization and Vermont Legal Aid, and they took pieces of both and sort of put them together to make something that didn't look like what either of us really proposed, but is sort of a compromise. And I mean, it's workable. And I would say, like Wendy said, there was a lot of time spent on trying to get the language right here.
And I appreciate this. Actually, two of these provisions working together address two of my landlord constituents, our landlord in Windsor County constituents who want to move back and who have a tenant who is able to pay and isn't paying because they're just sort of, dare I say, hiding behind the eviction, using the eviction moratorium as a shield. And they qualify. I don't believe they would qualify for Vrap. And this is also a landlord who wants to move back into their home. Angela has been representing them. So that's one of them. And the other one, so actually both of those provisions actually would work well for at least two of the many landlords who've been in touch.
And the other thing that this provision does is make it very clear to the courts what the process is, because particularly at the beginning of the moratorium, there were emergency cases brought, and sometimes the court would jump into the merits of the case in the first hearing, and that was problematic. So this sets out what the process is, the rights of the tenant to get notice and to be heard, and that there's only going to be an order after a hearing. So I think there's a lot that's very positive here and nothing that's very troubling.
How would you assess if we didn't have landlord-tenant moratorium, and we were just relying upon the court's lack of resources and limiting their cases to emergency cases, do you think there would be a lot more eviction actions pursued presently?
I think there would be many more filed. Then it's going to be up to the court, how it handles them. And, it's always a balance for the court to bump the emergency cases ahead. Maybe I shouldn't say balance, but the court has to make a consideration here. Am I going to bump this landlord ahead of all the other landlords who have had eviction cases pending for 18, 24, however many months that they've been, and that haven't been finalized? So, the courts are not in a easy situation. And Angela and I have a meeting with the courts later this week to specifically discuss what's going to be the rollout after the moratorium ends. And I hope that we'll be discussing how VRAP will fold into that as well.
Okay. Thank you, everybody. Is David still with us? Yes. David, could you just take 2 minutes and zip through S79 as to areas where we've made some questions or comments that are left? I think the bill is in pretty good shape. It may even be subject to a concurrence, but I just want to, before we leave it, I just want to refresh people's mind of what other issues may still be outstanding based upon what you've heard.
I think it seems like all of the pieces about migrating DPS to DPS authority for rental housing, health and safety seems to be pretty well set. I would note that the Ways and Means Committee has an amendment that sort of streamlines the registration process and duties, which I think most people agree is an improvement to the bill. And it just sets a date certain of March 1st for any unit that was rented in the previous year to rent to the department, to give that data and that registration to the department. It doesn't seem like a very big deal about the appropriation as far as like 100,000 to DPS and 300,000 to DHCD to get things up and running. And then they'll be able to expand as the fees come in. I haven't heard you all express any significant misgivings about VHIP as it's structured. I will say, the revolving loan fund program is obviously something that was not in your bill, so that's a brand new item for your proposal from the House. Right now, the the House Appropriations Committee is set to take this bill up this afternoon, and it does have money in it.
They still haven't passed it out? I thought they were meeting yesterday.
No, they are scheduled to take this up today. And so this has $3 million of general fund for VHIP and $1 million of general fund for the revolving loan program. And then it has 400,000 for the positions at DPS and DHCD. So, what House Appropriations does with that money today, I'm not certain. I'm not certain what's going to happen. And then the last piece is the eviction moratorium, which you've just discussed. And that's what I know in 2 minutes.
Well, by the time we get this, we're basically going to have to concur. It's not going to.
Well, no, I mean, if we made a legitimate point that the House, that was non-controversial, if the House agreed to, they could put that on the bill on the floor and send it to us. But I mean, that's another option if we felt strongly about something. But I think it's in pretty good shape.
Yeah.
And
Good work, you guys.
okay. can we go offline?